I'm delighted today to be joined by my colleague Mitra, who has a very interesting specialism and dual practice area. So, Mitra, would you like to introduce yourself and tell me all about you?
Yes, absolutely. Well, how far back do you want me to go? I can go as far back as my background, where I'm from. Um, I was actually born and brought up in Mauritius and moved to the UK to do my degree. I initially thought I would do an English and French law because I speak French, as well as numerous other languages coming from a multicultural and multilingual island. Then when I came here, I decided, oh, I actually like English law, so stuck to a 3 year degree doing English law, obviously my honours in law, and then did my LPC, the usual route to qualifying as a solicitor. Then I entered the world of contentious probate as part of my training. And from day one, I was just mesmerized. I've found the whole world of contentious probate absolutely interesting, amazing. The opportunity to help people. I think it sits very well with the sort of person I am, with my personality. So with contentious probate, it involves a lot of challenging wills, inheritance disputes. Sometimes you have disputes with executors. And one of the key sort of areas that I was looking at quite early on in my career was lack of testamentary capacity. If somebody had made a will which was being challenged, what do we do about it? How do we address it? So whilst I was looking at all of this as a contentious probate lawyer and looking about, what happened to this individual who somehow ended up making a will when clearly they did not have capacity or were vulnerable. We are dealing with all of this now post death. Then I started thinking, oh, hang on, why wasn't there anyone there to help them whilst they were alive? Who's actually looking after them? So as a result of that, I sort of branched out about 12, 15 years ago into the world of court protection, which is where you help people whilst they're alive and help those who do not have the capacity to make certain decisions, such as making a will, financial decisions, etc. As a result of which, I've got dual specialism. I specialize in contentious probate, will dispute, as well as contentious court protection work. Passionate about both areas. So passionate about the latter one that a couple of years ago I wrote a book about gifting in the court protection, just to remind attorneys or educate them in case they were not fully aware of the scope of their powers about the scope of how far they can go when it comes to gifting, because it was sort of a trap I felt that they fell into quite easily because of not knowing what they can or cannot do. So I wrote this book. I believe quite a few people found it very helpful. And off the back of this, I'm now writing my second book, which is on the financial abuse of vulnerable people and how or when to remove an attorney or a deputy when they have misbehaved.
And it's really interesting space, isn't it? Because I know you and I both come at it in the same sort of way, because I also do court protection work. And
Absolutely.
it's that point where you're going, just because you've got that bit of paper that says you're an attorney or a deputy doesn't mean you can do what you think you want to do. There are rules. There's the Mental Capacity Act. There's a code of practice. There's all these cases, and seeing it, and I think people just don't realize how big a job it is.
It is. And and that is in my book one thing I do address, because I was trying to think about how can I get all these inquiries about people asking me questions, and I'm thinking, well, you should have known about it. And that's when I sort of identified a gap in our system. So a typical example, you as a private client solicitor and court protection solicitor, someone will come to you and say, Heledd, I'd like to make an LPA because although I'm fine now, I just want to put my affairs in order. And even if whether I'm fine or not, I'd like someone there to be able to help me with my paperwork, finances, etc. Absolutely fine. You probably would sit down with them and say, right, this is what an LPA means. This is the powers you're giving to them. If you don't give them any restrictions or do not put in any restrictions, they can use your power of attorney to make financial decisions now. Very likely they'll say, yep, absolutely trust. In a typical scenario, my children, they will do right by me. Absolutely fine. You've advised your client, they sign the power of attorney, you send it off to the children, very likely with a covering letter to say, this is the responsibility you're taking on. Please refer to the Mental Capacity Act, the Code of Practice, etc. Attorney sees it, say, yep, of course, I'll do what's right by parents, sign it. Let's be realistic here. Nobody's going to go and read the Mental Capacity Act or the Code of Practice, which is hundreds of pages, before signing this power of attorney as an attorney. So the attorney, it's registered with the OPG, all fine, good and dandy. And then, hey ho, the day comes when they have to rely on it. Very likely, time is of the essence. Certain decisions need to be made urgently. And they make decisions based on what they feel is right for their parents, or sometimes even what they feel is right for themselves, because they know ultimately they will sort of benefit from it all as a beneficiary. So this line between wearing the hat of a child or a close family member and the role of wearing the hat of an attorney, this line gets blurred. And I've spoken to many attorneys over the last few years, and sometimes the answers they come back with actually it is quite surprising to me as a practitioner, but I think may not be surprising to many. And in fact, I'd like to read a few of them out because I think you and many others will find this relatable. So a few of the things that I've sort of heard from them, and I actually mentioned them in my book, is what I've heard is classic one is let's say I'm asking about a gift or a transfer of property that had been done by the attorney in his capacity as an attorney. Things that I've heard is, well, P, being mom or dad, whoever it was, had capacity and said that I could have the money or the property. All good, they think that put the ball back with the donor, the LPA, they had capacity and they said I could have it. Really? But is it in their best interests or not? That's another issue. What I've also heard is, well, P would have wanted me to have the money if only they had capacity. Yeah. Well, maybe that was relevant a few years ago when they had capacity and maybe had better control of their finances and had a lot more money. That may not be the case now. The other thing is, it's a classic one, and I'm sure you'll have something to say about it. It will all be mine soon anyway. So what
just
is
don't.
And then I've heard, I deserve this for all the sacrifice that I am making. Yeah, and in some cases it is correct in the sense that I know many attorneys I've spoken to who have given up their livelihood in effect to look after their parents, and I'm not disputing that at all, and this should be recognized and acknowledged, but it is in everybody's best interest to make an application to the Court of Protection to seek permission for them to be compensated in a certain way through, maintenance payment or something of the sort, to recognize what they're doing. So I'm not saying that nobody should look after a vulnerable person because they can't get anything. It's just that there's a route, there's a procedure to follow. The other thing I often hear is, I will return the money if P ever has a need for it. Yeah, that's all good. There was probably a reason why you needed to take the money, and how do we know whether you will have the money at the point when P needs it? Because you may be in debt, you may have other financial sort of obligations. Um, and the other one I've heard is, if P does not mind and is well cared for, then what is the harm? Yeah. So these are a few sort of, they are what I call common misconceptions, and very often um, it's because of a lack of awareness. It's because they do not fully understand what it means to be wearing the hat of an attorney, and what a fiduciary duty is, and how they shouldn't mix their finances with the donor's finances, and should always put the vulnerable person or protected person's interest first. So that is something that I feel very passionate about in the world of court protection. And alongside this, I do contentious probate, which is another exciting world that we live in. And I see all sorts every day in my line of work. There's a lot of news at the moment about how probate disputes are on the increase. Many reasons for this: aging population, so more vulnerable people making wills perhaps in the latter phase of their life, where there's a question mark about their capacity, whether they're being influenced, whether they have knowledge and approval of what they are doing, and also with people in effect being more affluent. As they're getting older, there's a bigger estate to fight over. So these are a few of, I believe, factors that are contributing to this increase in contentious probate cases. And it's a world of its own, with just a lot of talk are being held, seminars, webinars, to really make will writers and private client solicitors very aware of, particularly when they are dealing with vulnerable people or people of a certain age, to make sure that they are taking instructions from that person, that if there is a question mark about the capacity to get a capacity report, what we refer to as a golden rule, which is not a legal obligation, but certainly is a very, very good guidance. And there are changes being recommended by the Law Commission about the making of wills, etc. So exciting times ahead.
And I think it's really interesting. So you're talking something there about the two areas you work in. One, which is contentious probate, which, in technical, is covered by civil procedure rules. And then we've got mental capacity court protection, which is court protection rules, and they are different.
Yes, so that's right. I mean, I talk about attorneys wearing two hats and everything. I myself wear two hats.
Yeah.
So I've got the court protection rules that have changed since I first started 15 years ago, and you need to keep yourself up to date. The practice directions change. I mean, Heledd, you and I were talking the other day about, at what point should attorneys go and seek sort of the court approval for certain actions, because the practice directions have slotted a few sort of bits on their list of when they should go to the court, or when they may seek the approval of the court of protection, etc., for equity release, etc., and things like that. So it's constantly changing. The Mental Capacity Act is a different act, different court of protection rules, different practice directions. Then contentious probate, you've got the CPR 57 to deal specifically with this. You can have Part 7 claims for the typical will disputes, will challenges, or a Part 8 claim when you're dealing with a claim for reasonable financial provision under what we call the 1975 Act, which is the Inheritance, in brackets, Provision for Family and Dependents, close brackets, Act 1975, a bit of a mouthful, so we call it the 1975 Act. So that deals with Part 7 claims, Part 8 claims under CPR 57, which has got own raft of practice directions. So yeah, so very often I have to sort of switch from one sort of court rules to the other, but there's a huge level of overlap in this, which is why I'm passionate about both, because I can see how it starts when somebody is still alive, and the implications if you don't put your affairs in order, or you do not sadly get the right experts on board about will writing or making you wealthy, etc. There's a ripple effect that carries on post death. So in a way, I am well placed to be able to see when somebody is still alive, and I'm approached about certain concerns about if we don't take certain steps now, these are the issues or problems you may face later on down the line.
I think you've got it's a balancing act, isn't it? Because whilst P donor is alive, they are at the heart of proceedings because it's them, and there's a presumption of capacity until demonstrated otherwise, and you have to put them at the heart of it and them at the forefront. And I always say it's a bit like children work, where it doesn't matter what everybody else thinks; it's personal child at the centre of it. As soon as that person's died and it becomes contentious probate, it's about the money. It's probably about the money when P's alive, but you've actually got P there.
Yes.
Once you flip it, you're looking at this is about who gets what. And so I think, do you have to sit there and go, well, because P is by and large vulnerable or, unwell, or, we don't know what the life expectancy is. Do you have to put the two together and go, I am going to think about how I'm dealing with this as whilst P is alive with one eye on this is going to become a contentious issue post-death, and balancing both things up?
Yes, so a typical example, for instance, and I stress on that actually in that book that I've written, the first one, about, for instance, gifting. Typical example, there is an estate there, and one of the attorneys is considering gifting for numerous reasons, whether it is an excess in capital, a surplus that could go to the attorney or to another recipient of the gift, a grandchild or whatever, as I said, for various reasons, sometimes inheritance tax planning. So that is something that we would be looking now, bearing in mind P's finances, any foreseeable future needs, financial needs, medical needs, etc., their life expectancy. But one of the things that need to be looked at is the will which P has made, which will take effect post-death, because you don't want to be, or you want to avoid making a financial decision during P's lifetime, which may frustrate the will in the future. So classic example, there's a will that leaves one property to child X, and child Y is an attorney, and they need to raise funds for the payment of care home fees. Now, there are probably some investments that could be cashed in and pay for those care home fees, but they're insisting on paying that, on selling the house that if later on would go to Y. Or did I say X? I can't remember now. But what I'm saying is the attorney should consider, if they sell the house as the first sort of recall, then they may be frustrating P's will and testamentary wishes. So are there any other source of funds which can be used and which is more easily accessible to use for P, so that P's care home fees are still met during P's lifetime, and yet P's wishes in their will not be frustrated at a later date. However, there are circumstances where it doesn't matter sometimes what has been left to a beneficiary in the future, because the key person to sort of look after here is P. So there are circumstances where if the house needs to be sold, whether it's been left to X, Y, or Z later on or not, but P is struggling to make ends meet or to pay for their care home fees, then regardless of what's in the will, if the property is in P's name and it needs to be sold to help P during their lifetime, that needs to be done. But at least the attorney has gone through a process of looking at what is in P's best interest, and also looking at whether it's going to, their decisions today is going to have a major impact on the future.
It really is, isn't it? Because it is that balancing up. And I think, some of the conversations I have, and you've alluded to it, is that, well, it's what they would have wanted. Like, but I have to point out, when they had the opportunity to do it, they didn't do it. So why didn't they do it? And what's changed to mean that, because we might all go, well, yes, from an, if you were sitting down and having loads of time and doing your tax planning, you'd obviously go, well, I'll mitigate my tax as best as possible. But if somebody goes, yeah, I know that, but I'll get round to it, and didn't bother, then the expectation of the sort of recipients who go, well, they didn't do it, they should have done it, the court will obviously approve it. You go, well, no, it's a little bit more complicated than that, because
it is. And when it comes to tax planning, there's this case of JBC, I believe, and I think you need to show that it's not just because there's excess funds or surplus capital, let's do tax planning. I think the court of protection would want to see more than that. If P was in the habit of seeking tax advice, so that now that they've lost capacity, but let's say if they still had capacity, they would have gone and sought legal advice or tax advice, and perhaps then done that gifting for tax planning, then the court is more likely to approve such a proposal. But if P has never sought tax advice, does not even know what tax saving is or planning is, and then all of a sudden you're asking the court to remove, let's say, £300,000 from P's current estate for a future tax planning, which actually will benefit the beneficiary later on in life. Currently, you're depriving P of £300,000 without any explanation that P actually was in the habit of doing so. And if they had capacity now, they would have thought that's sort of what they would have wanted to do, in line with their historical behaviour. But in the absence of that, the court of protection is likely to be reluctant to approve such a gift. So yes, it's not simply if I spoke to mom or dad or P about it, that's what they would have wanted. You're quite right, Heledd. It's not as simple as that.
if only.
Yes.
It's evidence gathering as well, isn't it? It's that sort of, well, what have you got? And I'm increasingly finding that people are doing their structuring of personal affairs, say, and they're going, I've done lots of complicated structuring of my personal affairs, and I've taken advice, and I've set up trusts, and I've set up companies, and I've got a power of attorney, and somebody's lost capacity. And all these things start to ping and trigger like effects, and you go, oh, the unintended consequences of setting it up in that way means you've now got to, you can't do anything now without court approval, or and I think that, with people's desires, I think from one at the other end of the scale is people who are doing tax planning and who are doing sort of complicated things, and then there's an intervening event where somebody loses capacity, so then have to go, I'm really sorry, you can no longer do that. It's hard, and then getting that approval from the court point, we know is lengthy, and they are looking P's best interest, and you sit there and go, yeah, but this is a scenario where everybody was involved, and we've just been caught up on some technicalities. And I think that can be quite hard for people to understand.
It is. It is very hard for them to understand. But at the end of the day, say it's the whole evidence gathering, and if you sort of put it to them and explain, very often with inheritance tax planning or gifting of some sort, and it involves, when it comes to tax planning, it involves very large estates. So when you're gathering your evidence and you are sort of putting together figures as to what what the life expectancy is, let's say 5 to 10 years, and then you look at what their foreseeable future medical financial needs are likely to be, and let's say for illustration purposes, £1 million, and you then put it to them that, okay, we know that they will need £1 million, but we will ring fence a larger amount to give them this comfort, this security blanket sort of thing, so that if things do not go as planned and they need more, we have got this sort of funds. And then this little bit of extra, which may not be as much as they expected or they wanted to have gifted or to do tax planning with, but if they can see that after taking into account all the sort of likely outgoings, etc., which will be in P's best interest, and that is available, and this is what we suggest you make an application to the Court of Protection for. They very often understand our reasoning behind it and how we're putting P's needs first during their lifetime. So then it becomes a little bit more palatable to them, to the potential applicant, and more acceptable, because they can see the reasoning how we've come to this decision, or to our advice as to what we should do. But it's an interesting comment you made about the evidence gathering, because we do a lot of that in contentious COP applications, but also a lot of it in contentious probate. So I remember once I was asked by someone, so what's contentious probate really? What do you do? And one of the things that came to my mind at the time was, I think I'm a bit of a private investigator there.
I can see that.
And because I thought, hang on, we are lawyers. We apply the law. We see where things fit, and then we put a case forward. But before we get to that stage, we need to do a bit of evidence gathering. So I fancy myself a bit of an investigator, where for instance, a case where we're challenging the validity of the will, we need to look at the medical records of this person around the time when they made the will. So it's quite interesting, because you'll go through their medical records, you'll pick out comments from doctors or consultants if they were hospitalized, about whether they were getting forgetful, whether they could focus on conversations, understood what the doctor was saying, memory problems, or sometimes the medication that they've been prescribed, because some of them can have an effect. Obviously, I am not a medical expert. It's just the information I need to pass it on, or to form a view whether a medical report is required for this. But certainly sufficient evidence to put in a letter of claim in the first instance if there are doubts about this person's capacity, because this is mentioned by professionals in their medical notes. So I find this bit of my job quite interesting. And alongside that, we ask for a copy of the will file, what we call a Lark versus Nugas request. And that's another interesting part of my job. I will go through the will file and see the sort of conversations that has happened between the will writer and the testator, or the one making the will. And it's I have seen will files that have been pretty shocking, where people have asked very closed questions, such as, so you want to make a new will? Yes. So you want everything to go to your daughter? Yes. And it's pretty shocking, because helpful to someone who's trying to challenge the case, but really sort of a bit sad sometimes, because it will be I'm not seeing that a lot nowadays, I must say, but there have been in the past where it was more of a box ticking exercise. Ask them whether they want to make a will. Yes. They want to leave it to X, Y, and Z. Yes. We'll arrange a sort of time to sign it. Yes. All good. Fine. They've got capacity. There were days when I did not see open questions, such as, so what is in your previous will, and why do you want to make a new will? Has there been a change of circumstances? What has happened to make you come here today? And conversations where you engage with the person to really get into the depth of is it really what they want? Is it coming from them? And, just a very, very a satisfactory explanation really as to why they're changing the testamentary wishes. Because, revising a will is recommended. If anything, people should do that, should carry out a little health check every so often to make sure everything is in order. But having conversations like this really helps to sort of protect this person's instructions and protect or help with defending a future challenge to a will. If the work was done properly, there was a very, very in-depth conversation where both parties were engaged, and a very straightforward evidence and recollection of what was discussed. So that is another part of my investigation. So I look into will files, I look into medical notes, and sometimes even get a retrospective medical report. But what case law says is that a judge would much prefer contemporaneous notes to retrospective report notes, which is understandable, which is why my focus is, let's dig into what happened around the time when the will was made. What was that person's state of mind? What were they thinking of? What made them go to the solicitor and want to change it? So gathering evidence, going back to the point you made earlier.
And it is one of those things when you are taking instructions, you have to be really nosy, and you go, come on, talk to me. What's going on in your life? And it's almost like playing bingo, and you kind of go, okay.
I like that analogy. Yes.
So you go, oh, we've had a bereavement, we've had a fallout, we're going to go, okay. And like I say, I can count on the fingers of one hand the number of clients I've had who come in who've got a straightforward family dynamic. There's always somebody who's out of favor or preferred over the other one, and you go, okay, if you're going to do anything that's not completely vanilla, we're going to cover, we're going to throw the kitchen sink at this. So when I do get ones who are like, no, we are genuinely a very close family, and I'm just going to leave everything to the kids, I'm like, it's great, it's lovely, like more of this, please.
Yes. And something as well to sort of, which I'm seeing of late, there are many cases that's post-death coming to me, and they're challenging the validity of a will, but it also transpires that whoever is probably the main beneficiary of this will which is being challenged was also an attorney under previous LPA, and then you need to sometimes dig into their conduct, whether there was any form of mismanagement of peace funds during their lifetime, because if there was and they breached their attorney duties, then that may be a separate claim to try and claw the money back into the estate before it's distributed. So quite rightly so, you have a family set up where, yes, everybody gets on well, but only one is an attorney, the others are executors, beneficiaries, etc. And then you find out post-death that they are blaming each other for some form of conduct which took place pre-death as well as post-death, and it becomes very, very complex.
And it is amazing what comes out of the woodwork, and it's amazing when you sit there and go, you're trying your very best to sort of go, yes, this seems quite sensible, this seems quite logical, and then there isn't a dispute when the will's made, but the fallout after the event is quite spectacular. So because people go, oh, well, I feel hard done by for whatever reason, and the person who made the will isn't here now, so we can actually let it out.
Exactly. Yes.
And I find that quite hard, because you kind of go, well, you're doing your level best to take instructions and do what they wanted, and then it's all boiled over after the event. It's the grief and money point after the event. And you go, it'd be really handy if, we'd known this beforehand.
Yes, exactly. But there is a reluctance, isn't it, for particularly parents when they reach a certain stage to, they don't want to badmouth any of their children. They don't want to fall out of favors with any child, because what I have also seen is very often that they're hoping that one of them will look after them in the future. So why burn your bridges now? But knowing full well in the background that there are things brewing, but they don't want to say it out to an outsider, such as their solicitor, because they don't want to wash the dirty laundry as it is. But what they don't realize is this is likely to have this ripple effect, which I mentioned, that starts from now, but that will continue post-death.
And I think, just to bring us full circle, I think that the sort of mental capacity attorney, vulnerable elderly client person that's going to, that's done their estate planning, and it's all going to come to a head when they die, because it's inevitable, and then it becomes contentious estates. I think we're just going to see that grow, because I just think that you can see it brewing while P is alive, and you can see this kind of perceived imbalance in the family. So even if P's been completely fair, or in their mind everything was fine, it's not, because of this perceived situation. And I think that's I foresee that's going to be something we're going to see more of. That claims are made because people think they should, they're entitled.
And now claims are being made, after P loses capacity, claims are being made pre-death about clawing back money, and also about wills. I mean, we have statutory wills that people can apply for if a will was made under suspicious circumstances, and there are certain specific circumstances in which the Court of Protection will step in. The Court of Protection's jurisdiction does not extend it to make a decision whether a will is valid or not, because they will not be dealing with that, but they will be dealing with what is in P's best interest, and whether they are leaving a particular will open to being a challenge later on. That's going to cost a lot, whether it is, given the evidence the Court of Protection has before them, whether it is in P's best interest to make a statutory will to avoid a future contentious probate or will challenge case later on. So yes, steps are being taken. I think it comes down to people becoming more aware of what is going on, and hence I've really wanted to follow up with my second book about financial abuse and spotting the signs, what to look out for, and this is what it will deal with, what to look out for, who to contact in the first instance. I'm not saying, as soon as you hear financial abuse, let's go to court. No, it's not as straightforward as that. You can turn to certain organizations, authorities to try and help you and safeguard this person now, with other steps being taken. So with people becoming more aware of what actually happens behind closed doors while somebody is still alive, we will see, as you say, growing applications pre-death as well as post-death. And really,
so on a good note, when is your book out? When is your second book
published? Yes, the plan is it will be out early next year.
Fantastic.
So with my publisher, we have agreed that I will send the first draft in January. So hoping it will be published early next year. But this one is actually has been very helpful to many people, and to me. I mean, yesterday I got someone in the team calling me about what case law for capacity assessment for certain decision, whether it is litigation or whether it is whatever, because I've done all the research and put it all in one book. I was like, oh, Masterman versus hyphen Lister, and you've got it all in one.
Well, I'm pleased to announce it's on my bookshelf as well. Hey!
Thank you very much.
Mitra, it's been brilliant to chat to you as ever. Thank you so much, and know where to find you, and I look forward to your second instalment.
Marvelous. Thank you very much, Heledd. Lovely speaking with you.